I just got sued in small claims court. I'm a defendant. What do I do? I'm going to give you 7 steps you should take as a defendant in small claims court coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. Very grateful to have you. This is Jordan Farkas. I'm a retired attorney. I practiced for many years, also helping clients with small claims court disputes, whether plaintiffs or defendants, i.e., plaintiffs the ones suing or defendants the ones who were sued. And I've written a lot of books on court procedure, including small claims court procedure. Very grateful to have you. A reminder, if you have not yet hit the subscribe button, if you can do that and hit the notification bell, it encourages me to continue producing videos just like this, and then you won't miss a future video as well. So we help each other. And if you have subscribed, thank you so much for doing that. I do see the subscribership base continues to grow from each video. I have to make a confession. It's pretty funny. I recorded a whole long video and it was not recorded. I thought I hit the record button, but I hadn't. I'm checking now. That's how traumatized I am. So this is round two in redoing all of this. I'm going to try and be as thorough as I was in the last video. And in today's video, what we're talking about is if you are a defendant and were sued in small claims court, what steps should you take? And I've got 7 steps that I'm going to tell you about. By the way, you may have noticed as well that I'm a little more casually dressed today. We're still in the new year, so I'm still in I guess, the more festive season. I didn't put on my usual black shirt that I put on for these videos because I am retired. So it's not like I walk around in button-down collared shirts all the time. But also, this is the first video I'm doing from the perspective of defendants. So I don't know, just mix it up, something different. So let's jump right in. 7 steps a defendant should take when they are hit, or you, if you are a defendant watching this video, with a small claims court lawsuit. I've got my usual trusty whiteboard. For those who have seen previous videos, you'll be familiar with this. If you have not seen my earlier videos, this is your first time on my channel, first of all, you can check out my bio on the video introduction on the homepage of the YouTube channel. And you'll know, or now you'll know, that I'm a little old school in the sense that I'm not that technologically proficient, so I still have an old school whiteboard. Okay, so let's jump right in. Number one on the list, and this is for you defendants. By the way, I meant to mention, see, a lot of this I did in the earlier video that I forgot to hit the record button on. If you're a plaintiff watching this, there's a lot to gain from this as well, because it's always good to see the perspective of how a defendant will look at things. Okay, so now you're going to hear from me as a retired attorney how I would sort of counsel or guide defendants to prepare in response to a lawsuit. So if you're the one who filed the lawsuit, it can give you some good insight into how a defendant may approach things. And that's always good to see things from that kind of 360-degree view. So let's jump in. Number one on the list is to examine the claim thoroughly. Okay, now this is obvious sounding, and it probably is obvious to a lot of you, but a lot of others who get lawsuits tend to get very angry and emotional, or they just don't want to deal with it, so they just kind of toss it to the side and never look at it again, or decide to look at it a year from now. And that's a big mistake, as I'll talk about later, when it comes to time limits and things of that nature. You have a ticking time limit the minute you are provided with the small claims court lawsuit. Okay, so you want to make sure to review the claim thoroughly. And also, you're going to be defending against this claim. So when I say claim, I mean the lawsuit, what the plaintiff is saying, the person who sued you, what they're claiming you did or didn't do, and how much money they're claiming you owe them. You want to see all of that and understand exactly what their case is against you. Even if it's infuriating, which it will be, and aggravating and upsetting, you need to do that in order to have a better perspective so that you can prepare that much more of a stronger defense. So don't just say to yourself, I don't care what they're saying, they're jerks or whatever. That may be the case, but you should care what they're saying because you have to respond to those in the small claims court lawsuit. Also, the claims themselves, like in Ontario, Canada, where I'm from originally, for example, will give you all sorts of information about what you have to do next, the time limits that you have to file your defense, things of that nature. So it's very important to read over the entire claim thoroughly before you do anything else. Number two on this list of 7 steps is to read the instructions and the rules of the small claims court in the jurisdiction where you're at. So I know, for example, in Ontario, Canada, they have the rules of small claims court over there, and it's a whole bunch of rules designated specifically, as the name implies, for small claims court. And your jurisdiction where you were sued may have the same thing, so you want to look for that. Most most jurisdictions, I should say, for small claims court disputes do have a government website where you can look up information about small claims court on it. Though I have to say, I have another video series on small claims courts around the United States, across the United States, I should say, and I'll try and put up that card over there. You can click on that if you want to look for a state where you were sued. Maybe I've done a video for that jurisdiction. Again, that would be from the perspective of a plaintiff, but still, there's some more information there. It's a long process. It's a lot of research for me to look up all that information on every state, and I plan to get to other countries as well, of course. I just started with the United States. But my point here, in a long-winded way, in a lawyerly long-winded way, is just to say that when I was doing research for various states across the United States, not every government had a website devoted to explaining small claims court rules and procedure. Okay, so don't bank on it per se, but try and do whatever research and diligence you can to find information. Just be careful, okay? Some places will not give you good quality information. ChatGPT doesn't guarantee accuracy. AI can be very useful, of course, in this day and age, but always be mindful that it's not always necessarily so accurate or the most up to date. I've seen people posting things on Facebook that has been so wrong about small claims court procedure over the years. That's not to knock Facebook, but just be very wary of getting guidance from people that actually don't aren't attorneys or aren't those really experienced in small claims court. Again, it's not to say you have to disregard comments or people's prior experiences, but don't take that for gospel, so to speak. Try and get it from the source. See if there's a government website. And this ties into also, speaking of getting it from the source, number three, consult an attorney. Okay, now again, this depends on whether or not it's financially, I say again because I've mentioned this in earlier videos, there's a lot of overlap in a lot of these concepts. So forgive me if you've already heard this from me before, but if you have a $100 claim, for example, it's not going to be financially feasible to consult with an attorney. But if you have a claim for $10,000 against you, then it may be prudent. In fact, I would suggest it is prudent to consult with an attorney, even if it means laying out some cash up front, because that money could be an investment to save you from having to spend more if you were to lose your lawsuit. Of course, no lawyer or attorney could guarantee that you'll win your lawsuit, but I feel that you're in a better position to win and make better quality decisions based on your consultation with an attorney. Of course, it depends on which attorney you're consulting, but nevertheless. And by the way, this applies even if you're in a jurisdiction where attorneys are not allowed to practice in small claims court, where they cannot represent you. They can still offer you guidance and assistance because in many cases, the small claims court lawsuit is no different than a higher court lawsuit, just minus the zeros. It's just a smaller amount. But a lot of the time, the legal principles and strategy of how to approach it, negotiating, etc., are the same. Okay, so don't discount consulting with an attorney, even if you're in a jurisdiction where attorneys aren't allowed. And again, I feel it's very prudent to do so, assuming it's financially feasible, depending on the amount of the lawsuit in question. Number four on the list is to prepare a timeline. Okay, now this is very important. Before you just start scribbling your defense in response to the claim that you were provided with, it's called being served. You were served with the lawsuit. Before you provide your defense, you want to write out a timeline so that everything is clear on your head. From the moment you had first contact with this plaintiff, with the person suing you, up until the point where you were hit with this lawsuit, try and put that in point form and actually write it down or type it out if you prefer doing it electronically. But make sure you have that timeline clear in your head. This will help you prepare a much better, more logical, coherent defense. The defense being the document you'll file in response to the claim. Again, terminology will depend on the jurisdiction where you're at. So in Ontario, I got used to that terminology. It's called a plaintiff's claim. That's the lawsuit. The defense is the defense. But some places it's called a response or a reply. But the point is the document you file after being sued to respond to what the plaintiff is suing you over, when you have that timeline, you'll be able to present the arguments in a more logical way. And also will help you prepare for trial. If you go to trial, you can present the facts that happen to the judge or the decision maker, whatever they're called, in your jurisdiction, the trier of fact, in a more coherent way. So prepare a timeline. Now that timeline will also include considerations such as, do you want to do a counterclaim? Okay, so for example, what does that mean by a counterclaim? You can say, not only do I not owe this plaintiff money, he actually owes me money, and that's called a counterclaim. It may be called something else in your jurisdiction, but it's essentially the idea that you're disputing that you owe money or all the money that the plaintiff claims, and in fact, you say that the plaintiff owes you money. That's a counterclaim. Similar but different is something known as a third-party claim. So third party means, well, even if I am responsible, which I deny, but if I am responsible to the plaintiff, it's not my fault anyways. It's a third person who caused this. So for example, let's say the plaintiff is suing you because they tripped and fell on your pavement and suffered damages as a result. Meanwhile, you had hired a paving company to pave your driveway and they failed to do it on time. Had they done it on time, the plaintiff would have never slipped on your driveway. At least that's the argument you would make. You would have to prove that, but you would make that argument. So that would be known as a third party claim. If you, as the defendant, bring in the paving company as another party, that's called a third party claim. Okay. Once again, the usual caveat, every court is different. Small claims courts that I'm familiar with do allow for counterclaims and third-party claims, but make sure that is something that you can do in your small claims court as well, and it's something to consider depending on the facts of your case. And also, you should be considering, do you want to admit any portion of the claim? So, for example, if the plaintiff's suing you for $10,000, you may say, well, I don't owe you 10,000, but I'll admit to owing you two. Okay. Now, strategically, that can work in some cases. I'm not going to go down that rabbit hole. In most cases, defendants, at least when lawyers are acting for defendants, the defendants will deny it all and then start to leverage a negotiation by saying, okay, well, I'll grant you the 2,000 and go from there. But in some cases, it does make sense to simply admit the lesser amount, and maybe you have a you'll be able to resolve the case quicker if you're not arguing over things you shouldn't be arguing about. But that's a strategic decision. Another reason to consult with an attorney, by the way, because it could be hard for a layperson to make a decision like that. Okay, but these are definitely considerations that you should be making. Number 5 on the list is to gather your evidence. So the evidence is what you need to help prove your defense, what you're saying in response to the person who sued you, in response to the plaintiff. So that will include things like photographs, or it depends on the case, right? So photographs, text messages, email exchanges, anything in writing, receipts, documents, also witnesses. So there's also, in addition to documentary evidence, there's witnesses who can give testimony, who can say things in court under oath in your defense. So you want to try and line up those witnesses. By the way, even if you cannot find witnesses or witnesses are, well, I shouldn't say you can't find, but if witnesses are not being cooperative, there are mechanisms in place in most small claims courts that I'm familiar with, known as a subpoena or a summons in Ontario, it's called. But once you're getting into subpoenaing a witness to like force them to attend, they're already somewhat hostile. So it's not something that you want to necessarily rely on. So when you're going through your evidence, you want to bear in mind what sort of witnesses you can, gather around you to help you defend against the lawsuit that was filed against you. Number 6 on the list is to file wisely. So what do I mean by file wisely? Well, consider all the things that I talked about above. Do you want to do a counterclaim, a third-party claim? Do you want to admit some of your amounts? Do you want to dispute some of your amounts? Okay, so these are things that you have to really be mindful of. Oh, I almost forgot, by the way, something else to consider, which is very important as well when you are, before you file your defense. And this is kind of part of the knowing the rules of procedure are time limits. So there's 2 types of time limits that are applicable for this video anyways. Number 1 is, as a defendant, how much time do you have to file your defense? Okay, you can't just kind of file it away and then, when I say file it away, I mean like toss the claim to the side and decide to deal with it 2 years later. In Ontario, for example, I mean, I'm retired now, but when I last practiced, it was 20 days. Okay, so there's usually time periods that are given to a defendant to have to file their response or their defense to the claim. So most times that will be written right on the lawsuit so that you know, and that's another reason to review the claim thoroughly. But make sure you're aware of those timelines so that you don't miss a time period. There are mechanisms that even if you miss the time period and the court closes its gate, so to speak, to allow you to file, you can ask a judge later on. It's often known as a motion to allow you to file and give a good reason why you missed the time period. So don't despair if you're watching this and you already missed that time period, but you don't want to get to that position. Okay, so it's much better to be proactive and make sure not to miss any deadlines, of course. The other time limit that's very important for you as a defendant to know is the statute of limitations, often referred to, or the time limit that the plaintiff had to file their lawsuit. So let's say you had dealings 10 years ago and the plaintiff is only filing the claim now. So if this was in Ontario, for example, when I last practiced anyways, okay, so don't take this as gospel for today's rules. Somebody had 2 years from the date of discovery of the claim to file their claim. They couldn't do it after 10 years. So you want to check if the plaintiff maybe missed a limitation period. Again, an attorney can help you determine that too. And if the plaintiff rather missed the limitation period, you can put in your defense right there. Hey, the plaintiff is out of time to sue, so I should have a defense if for nothing more, just based on that alone. Of course, you should defend all of the claim in general. I don't give specific legal advice, but in general, you should set out why the plaintiff is not owed anything anyways. But as another backup insurance type of defense, you want to say that the plaintiff missed their time period. So it's very important to be mindful of timelines, both for yourself as defendant and also what timeline the plaintiff had to file their claim, so that you can rely on that possibly to argue that the plaintiff missed the time period that they had. So I talked about filing wisely. These are all things to consider. And finally, number 7 on my list is to follow up with the court. So once you file your defense, the court, in most cases, will mail you or maybe email you these days the notice of a trial date or some sort of upcoming hearing for small claims court. So don't just rely on the court to get it to you and not worry about it and say, like, all right, well, I don't see anything, and stick your head in the sand. You've got to be mindful of these court dates. You don't want to miss a court date. So make sure to follow up with the court once you file. And again, if you've already reviewed the procedure and the rules, you'll have a better understanding of what to expect. But still, make sure to check in with the court periodically to make sure that you're not missing any notices. I know it's annoying, but I'm not saying to be crazy and obsessive about it. You don't have to do it daily, but get a sense. Some places where you actually file in person, if you're not doing it digitally, you can ask the clerk, like, when do you expect to send out a notice about the trial or something like that, and they'll give you a general idea. But you be proactive about making sure that you're not missing any notices coming from the court. Okay, so just to review, and this is the second time I'm doing this because if you're just joining me on the video now, I forgot to hit the record button on the previous video that I did, and it was so good. I hope this one is as good. But in any case, let's go through the 7 again as a quick summary. Number 1 is to examine the claim thoroughly. Make sure you understand thoroughly what the plaintiff is claiming against you, how much money they're claiming, and what the form says about what your next steps are in the small claims court jurisdiction where you were sued. Number 2 is to read the instructions and the rules of the small claims court procedure in the jurisdiction where you add, so that you better understand what to expect in court and know what to do and when to do it. Number 3 is to consult an attorney, again, assuming it's financially feasible. It depends on the circumstances of your case. Number 4 is to prepare a timeline, and while you're doing, and that will give you a good chronology to give to the decision maker in court, both in your defense document and also when it gets, if and when it gets to trial. You should consider doing a counterclaim against the plaintiff who sued you if you feel the plaintiff actually owes you money, a third-party claim if you think somebody else is responsible, and if you want to admit any portions of the claim that the plaintiff is making. Number 5 is to gather your evidence, as we talked about, your photos, your text messages, what witnesses can you line up. Number 6 is to file wisely. I didn't mention this before, but in some courts, many small claims courts, you can file some or all of your evidence. So when I say file wisely, sometimes you don't want to show your whole hand right away. Sometimes you want to put your best foot forward and file everything. In some cases, if you don't file it right away, you cannot rely on it later. So be wise about it. Know the rules, know what the procedure says, and think about what your best strategy is to help you either negotiate a settlement if that's how you want to go, or to win in small claims court if it goes to trial. And finally, number 7 is to follow up with the court after you filed your defense document to make sure that you don't miss any future deadlines or court notices. I hope you found that video helpful. As always, if you have any feedback, very welcome to leave that in the comment section. I've been noticing an increase in feedback, and I'm very grateful. Just a reminder, I cannot give you specific legal advice, but I may just talk about something you raised in the comment section in a future video, or I may respond to you directly because the channel is still in its infancy, although it's growing, and I'm very grateful. And speaking of growing the channel, once again, if you could hit the subscribe button if you haven't yet, and the notification bell, we can help each other. You help encourage me to produce more videos, and you help yourself to get more videos just like this one on small claims court. Also the like button and sharing this with anybody who you think can benefit. And as always, I'm very grateful that you came to the channel, watched or listened as you did other chores, or however you watched or listened to this video. You're all welcome, and I appreciate it. And until next time, I look forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.